Welcome to today's Law Works Legal Primer Series webinar on wills, estate, and LPA matters. This webinar is organized by Pro Bono SG in collaboration with NTUC. My name is Serene, and I'll be your moderator for this webinar. Before we begin, here are some housekeeping matters to take note of. Today, we'll be using Pigeonhole Live for our Q&A session. You can submit your questions at any time during the webinar and vote for the questions by others that you would like answered. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Then key in our event passcode, which is LawWorks2401 as shown on the slide. Alternatively, you can click on the link in the chat function to launch Pigeonhole Live on your device. If you're viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Next, before you ask, we will email you a copy of the slides to you tomorrow. Finally, please note that today's discussion is not intended to substitute any form of professional legal or medical advice. If you require specific legal or medical advice, please consult a lawyer or doctor. I would now like to welcome our distinguished speakers for today's webinar, Dr. Liana Zailan, Mr. Patrick Tay, and Mr. Josephus Tan. Allow me to first introduce to you Dr. Liana Zailan. Dr. Liana is a consultant in general medicine and palliative medicine in Woodlands Health. She has been in both hospital-based and community medicine practice for the last 12 years. She currently works in palliative care consult services and hospice care services in various institutions in Singapore. Next, joining us on the panel today is Mr. Patrick Tay. Mr. Tay is the Assistant Secretary General of NTUC and the Director of NTUC's Legal Services and Strategy Division. He is also the Member of Parliament representing Pioneer SMC since 2020. Mr. Josephus Tan is the Managing Director of Invicus Law Corporation and specializes in criminal defense work. He is deeply familiar in working with young persons and was recently appointed by the President of Singapore to serve as a panel advisor to the Youth Court. Josephus is heavily involved in pro bono work and has been conferred numerous awards in his work in his area. Panelists, thank you for joining us. For today's program, we will cover wills and intestacy, lasting power attorney, advanced care planning, other life planning and healthcare decisions, useful resources and tips, and finally, we'll wrap up with a Q&A session. So let's kick off with wills and intestacy. I'd like to invite Josephus to discuss this topic. Josephus, why is it important to have a will, and what happens if you don't have a will?
Well, thank you, Serene, for asking that question. I think really on the topic of wills, right? I think that is really the ultimate question, you know, and in fact, it is a question that's commonly asked, you know, at all the different sessions and seminars or webinars that we have conducted over the years. So really, I think for our viewers, for our audience who are tuning into this session, right, you really just need to understand this, right? So essentially, there are two components to this. So why do you need a will? Or what's the difference between having a will and no will? It's just down to these two components. One is about time, one is about cost, money, okay? So simply put, if you are going to have a will, all right, that is going to save you time. Why do I say that? Because eventually, in all of us, one thing for certain in life, they always say that is death and another one is taxes. So that's the saying, right? So these are the only two certainties in life. Okay, around the world is the same. Okay, so when you passed away, which we all will eventually, okay, under the law, in Singapore is that all the assets under your name will be frozen. All right. And the only way to unfreeze these assets under your name is by way of a court order. So simply put, the court must give an order to say, okay, you know, the assets of this person, this deceased person, can be distributed. All right. So if you have a will, long and short of it, that means your wishes are in black and white, right? So I mean that there is a documentary hard evidence proof of your assets and who you want these assets to go to. All right. So it's really straightforward. So when you apply to court for this court order, right? When you have a will, this process is called a grant of probate. All right. Usually people will get a lawyer or a law firm to do it, or they can do it themselves. But the entire process of getting this court order, if you have a will, is usually about 2 to 3 months. And the cost, the second part, which I talk about, the cost involved, right, is I think market right now, the range is anything from maybe $1,000 to maybe $2,000-3,000. So anywhere between $1,000 to $3,000. All right. So bear this in mind. All right. That is the range. So to get a court order, if you have a will, okay, the grant of probate is going to take you under 3 months, and the cost is going to be under $3,000 or even lesser. All right. That is the current rate right now. As compared to if you pass away without a will. All right. So similarly, you still have assets under your name, but you have no documentary proof of your wishes, where are these assets, who you want to give the assets to. So likewise, okay, you still need the court to unfreeze these assets, right? Thereafter to be distributed. But because nobody knows, right? So end up, you will still apply to court for this court order, and this process, this application is called a grant of letter of administration, or in short, we call it LA. So coming back to the difference, right, between having a will and no will, if you are going to apply for this LA where you pass away without a will, cost is going to be more expensive. Because why? But the thing about lawyers, right, if you get a law firm or lawyers to do things, they are selling you their time. So if they are going to spend more time to locate your assets, they are going to spend more time, to manage the paperwork, so-called, to speak, right? Then it's going to cost you a lot more. So I think easily right now in the market, if you talk about an LA application, usually they start in the region of the thousands of dollars to the tens of thousands, right? So I think anything between about 4, 5, 6,000, it can go all the way up to 8 or 9 or even $10,000. So it's more expensive. Second thing is about time, because when you're alive, you never indicate your wishes, who you want the assets to go to. As such, nobody knows, you see. And nobody knows like how you want it to be managed, who you want it to be given to, so on and so forth. So end up, I think there's a lot of procedural stuff you have to do. So the time involved for obtaining a letter of administration from the courts, easily you're looking at about anything between 6 to 9 to even 12 months. So in short, you can see the difference. All right, having a will and no will essentially is time and cost. So if you have a will, you save a lot of time, you save a lot of money. If you pass away without a will, whoever is picking up after you, usually your immediate family members, they have to spend a lot of time and a lot of money. So that's really the long and short of it to your answer.
Thanks, Josephus. I think the next question, which maybe is on most people's minds, is that can I do the will myself? Because lawyers are so expensive. Can I draft the will myself, or do I need a lawyer for it?
Fantastic question. I love to answer this question. We all always watch movies, television show, especially some of these Chinese drama series, right? As those 古装戏, they show you like last time people of the past, how they do it. Or they bite their finger, use their blood, or even their last breath, right? They're going to say that I'm going to will this entire fortune to this person. Then they go and use their blood to seal it, right? To be honest, these are all for dramatic purposes. Because under the law, or at least under the current law, the will be invalidated. First and foremost, I think there are some legal requirements for a basic will to be recognized by the courts. All right. Things like, for example, of course, the will must be in English. There must be 2 independent witnesses. Okay. And there must be at least 1 executor, and there must be at least 1 beneficiary. So I think, of course, these are the basic criteria, the legal requirements. So, but in terms of the wording of it as well, it's very important to actually get a trained professional to do it. So under the law in Singapore, it doesn't say that only a lawyer can draft a will. I want everybody to know that. Okay, so please take away that misconception. A lot of people thought, oh, only lawyers can draft a will. That is not true. Anybody can draft a will, including yourself, if you know how to. If you know the language, you know the legal requirements, please by all means do so, okay? But no need to use your blood and sign, just use a pen and sign can already, okay? On every page, okay? So coming back, if you ask me, I think it will be better, safer to get a trained professional to do it. So this can be a professional will writing company, or this can be a law firm, or somebody who is legally trained and professionally trained to draft a will. That will be safer, because if you miss out any critical legal requirement, the entire will can be invalidated. So that means got do like never do like that. That means then what's the point of doing, right? Might as well do it and safely. So that will be my advice.
You know, you mentioned about independent witness. So what does it mean by that? Does it mean you cannot have your friends or family, because that's who you naturally would think of when you talk about witness?
Very good question. Okay. The rule of thumb, simple rule of thumb is this. As long as the person is not a beneficiary to the will, or maybe even to make it even safer, as long as you are not inside the will, you can be an independent witness. Like for example, if let's say I'm the beneficiary, you give all your assets to me, then I'm also the witness. Then like that it's like, your palm in front and palm at the back belong to the same hand, right? Like that, not right. So something is a bit off. So logically, when we say independent witnesses, these two witnesses must be independent from the contents of the will. That's what it really means. So they don't benefit anything from it. They just witness the signing, the formalities of the execution of the will. I think that's what it means. But of course, they must be mentally lucid must be above the age. They must be an adult, mentally lucid. You cannot just like pull some random people, a kid from the playground to go and just put their thumbprint or whatever. Cannot So they must witness not just the legal formalities of the execution of the will, but they must understand what's going on as well. Yeah.
There's an interesting question from the audience.
Okay.
Maybe a bit kiasu. What happens if I sign multiple copies of the same will and then I leave it with different people in case one person loses it? Is that okay? So that means as long as somebody has that copy, that's my will? Or is it all multiple copies?
Wow. Don't so kiasu leh. Sometimes they say too many cooks spoil the broth, Okay, I think it's okay. If you want to be kiasu a little bit, it's fine, provided it's the same will, meaning to say that the date, time, everything is the same. You see, under our current estate laws is this, the latest will determined by the date, right, will be taken by the courts as the final will. So you see, maybe now I will give you a story, a real life story, a real life case example of what we encounter. So we have seen a case of this old lady. She came with her daughter. So she, for example, she came last week. She did her will, executed, everything was fine. She gave everything to that daughter that brought her. 1 week later, she made another appointment. She came down, and this time around, she brought the son along without the daughter. She made another will, giving everything to the son. Okay, under the law, using an example like this, right, which is the latest, which is the last will? It's actually the one with the son, because the date is the latest. You understand? So why is this important? Because you see, for example, if you make one will today, it's dated today, but of course you can't sue. You want to make a few duplicated copies and let a few people keep. I think it's fine. But it will be a bit different now if you are going to make different wills at different timelines and give to different people with different duplicates. That is going to potentially confuse the matter, because at the end of the day, whoever are benefiting or not benefiting from your will or your second last will or your third last will or whatever it is, you end up being very litigious. They will start suing each other. They will say, oh, actually, she intended to give you, not me. She intended to give him, not her, that kind of stuff. So we always advise people, especially the elderlies, if you do your last will already dated today, you can do 1 or 2 duplicate and give it to whoever you appoint as your executor. Makes sense? Because whoever is appointed as your executor will be the one applying for the court order. So you want to make sure that that person actually has a copy of your last will. Entirely logical.
So a question that came was, and perhaps a fortunate person, what happens you have assets overseas? You have assets overseas and in Singapore. So can you just do one will in Singapore to cover it both, or must you do two wills in two countries? Like, how does that work?
Okay. Also, this is a very common question. Okay. There are two answers to this. Why do I say that? Okay, first, of course, something like a universal will concept, right? One ring that binds them all, you hope that you can just do one will, it covers all the assets in the world. Theoretically, it's possible, but practically not advisable. So I can tell you real life examples. Many Singaporeans, they actually not only have assets in Singapore, but they have maybe some assets in Malaysia, maybe some assets in China, and these are the commonly seen countries, or some in India as well. So first and foremost, there's an issue of jurisdiction because different law will have different legal system. So when we talk about Commonwealth nations like Singapore, Malaysia, Hong Kong, African nations, right? The former colonies, British colonies, more or less they share the same legal system, the same pattern one, same kind one. Then there's another kind, which is what we call the civil law system. For example, places like Germany, France, Japan, China, they have a different system altogether. Okay, so that is one thing, different legal system. Second thing is about the political situation in each country. So some people ask me, they say, oh, Joe, since you say that Malaysia, Singapore, same, used to be a British colony, so we share the same legal system. I have the apartment in KL. Can I write a will in Singapore to govern my Singapore assets and also the condo in KL? Answer is yes, you can, but advisable not to. Why do I say that? Because assuming you do that, when you pass away, right, your executor will get the Singapore court order. Okay, Singapore court order. Once the Singapore court give you the order, then the Malaysia side, how? You have to take the Singapore court order to go Malaysia side to do this process called reselling. Long and short of it, that means you need to get the Malaysia court to approve also to accept. So theoretically, it's possible. Legally, it's also correct. But why we don't advise it is because what if there's a change in government? What if suddenly there's a riot? All right. So I think over the years, we have seen, these are real life examples. We have seen the situation in our neighboring countries, politically or otherwise. Like, for example, even we see in Thailand, we see in nearby countries, there are wars, coup d'etat, governments have been overthrown the night before or whatever it is. There's a change in systems. So we will always say to play safe, rather than you go through this reselling process, which is correct, which is possible. Why not you do the will in Singapore to govern the Singapore asset? And Malaysia, you do another Malaysia will to govern the Malaysia asset. It's safer this way. So at that point in time whereby you need to execute that Malaysian will to unfreeze that Malaysian asset, right? So it doesn't matter whoever is politically in charge or legally in charge. Then you just follow that system there and then. All right, rather than asking the regime or the jurisdiction, the system there to accept the Singapore court order. You understand what I mean? So I think this is safer. So this is what we always advise people. Don't go through the reselling route. In fact, you should do the wills in respective country to govern respective properties. That will be actually the more prudent thing to do.
Great. A question you have was, I suppose nowadays more people have maybe pets and less children. And the question is, can I will money to my pets, and can I put like caregiving arrangement for my pets in my will?
Wow, very novel question, but I love it. So I can tell you something actually inside the will, apart from the basic legal requirements, which I told you about earlier, right? Having two independent witnesses, executor, beneficiary, blah, blah, blah. When it comes to the contents, the manner of the gifting, right? The sky is the limit. All right. So subject to your fantasy. So I've done thousands of wills. Some very romantic one, Give you an example. I have this couple, right? They are avid divers, So husband and wife, they came and do a mirror will. And they are both professionals. Okay. So these are educated people. So they say no children, but they love diving. So they said that when both of them pass away, or either one of them pass away, right? That wedding band must be taken to this shop in Australia. They specialize in making artificial reef. So they must take the person who passed away, that wedding ring, right? Must blend into this artificial reef. Then with the inscription of their marriage date. Then after that, they pay the company, the diving company, the money to bring this artificial reef with the ring, go down to the Great Barrier Reef and put it amongst the artificial man-made coral for eternity. So romantic, right? But you see, I told them, I said, so I wrote the will, I drafted the will for them. I said, no problem, wow, so romantic, I'm so touched, But guess what? I told them the reality. I said, okay, provided your executor will do it, okay?
And
Make
that's
you appoint the executor who is
yes.
equally a romantic like you, or very passionate about this, or just a passionate diver like you. Because if not, right, imagine you appoint, let's say, your brother who is a pragmatist, of like, people die already, burn already, forget it, lah, right? So they are also not, who is going to sue them, right, for not carrying out your wishes? So I think really what I'm trying to say is this: you can do a lot of things, but question, is it practical? Would you be there to make sure that your executor carry out your wishes? So if you want to give it to your pet dog or your pet cat, right, who outlive you, right? Okay, that is again quite impossible. But assuming they do, then you're going to, all the instructions you are going to give to whoever executor is going to take care of your pet, right? I think there's no way to ensure that they will do it, you see. I think there was a very famous celebrity who did that, who willed actually a bit of his fortune to his pet cat, will be Freddie Mercury, the lead singer of Queen. So I think he willed something to his pet cat, this ginger cat. But I think, you see, like I said, I don't know whether this concept will fly in Singapore. But so far, I haven't seen it yet, giving it to a pet. But I have seen somebody gifting their assets to animal societies. That one is quite common. Whether is it to like ACRES lah, SPCA lah, Cat Welfare Society. I thought one very novel one I came across, give to Hamster Society. Very interesting. Yeah.
So in short, you can be creative if you want to in terms of what you put in the will, including, I mean, another commenter also asked about funeral arrangements, but it sounds like since you can put in the diving request in there, I'm sure funeral arrangements is possible. And I think that segues quite nicely into another audience member question, is that, I came out with this will, and when I pass away, like, how would I know that my wishes will be carried out according to the will?
Yeah, exactly my point, right? So I think, you know what, first and foremost, you got to be very clinical in your approach, lah. So that's why we tell people, I mean, as much as you are romantic about things, and all that, but try to keep it practical. That's one thing. So that's easier for people I mean, it will be easier for people to be more willing to carry out your wishes. But more importantly, is really whoever you appoint as your executor must be somebody you trust. It doesn't have to be a family member. It doesn't have to be a kin or somebody related by blood. That's not required by law. As far as the legal requirement is concerned, he or she needs to be an adult above the age of 21. They need to be mentally lucid. That's all. So we have seen people appointing their best friends, or their church friends, or their organizational friends, their colleagues even, as long as it's somebody that you trust who will carry out your wishes. Simple as that.
So mindful of time, I think the next topic we're going to touch on is on the lasting power of attorney, which is commonly known as the LPA. So Josephus, maybe you can share with us, what is the LPA?
LPA. Okay, since just now we talk about will, so remember, ladies and gentlemen, will, if you draft already, that's not the end all be all. You know why? In order for the will to take effect, you must die. Okay? You must stop breathing. You must be medically certified dead. Then that is where the will can come into effect. So when you draft a will, you executed a will already, it's not over yet. That's the second last stage. For the last stage to come in, that means you're no longer around. Okay, that is will. LPA is different. LPA is when you're still alive. Okay, it comes into force the moment you lose your mental capacity. Okay, so very funny, fun fact, just digress a little bit. Some clients, they come to me, right? They say, hey, Mr. Tan, I tell you what, I want to do a will, but I don't want to do LPA. Or sometimes they come in, they say, I want to do LPA, but I don't want to do will. I always ask them, I say, so that means you are very certain you will die, but you will not lose your mind. Or the other way, that means you are very certain that you will lose your mind, but you are an immortal. You are going to live forever, is it? You won't die. So you see, the long and short of it is that if you do one, you should do the other. One is to protect your wishes after you passed away. Another one is to make sure your wishes are carried out on a daily basis when you're still alive. So on the topic of LPA, it's really this. When you lose your mind, when you lose your mental capacity, whether is it because of illnesses or sicknesses, like for example, dementia, Parkinson, Alzheimer, or maybe let's say a motor traffic accident, that created some sort of trauma to the brain that you cannot really function as per normal. You can't think or make decisions normally. This is where LPA comes in, but you still have to live. You are not dead yet, you know. You still have your bills to pay. You still have your banking obligations, blah, 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 right? Your day-to-day activities. So this is where I think you have to appoint somebody to take care of you, to make decisions for you. Whether is it for the first part, your personal welfare, or the second part for your property and finance. So there are two big components to LPA. So one is really to be in charge, to give the powers to take care of you personally, all right, your welfare, your day-to-day. The other side will be about your property, your assets, your finance stuff. Okay. So, and I think the concept is same as will. So for will, right, you appoint somebody to carry your wishes, you call that person an executor. But in LPA, when you appoint that somebody to take care of your personal welfare and or property affairs, right, that person is called a donee. Okay. And again, similar to will, essentially there are two things. If you have an LPA, if you ever lose your mental capacity, essentially you're saving on cost and time. You get a doctor to certify, okay, and straight away the LPA kicks in, okay, it saves time and it saves cost. But assuming if you do not have an LPA and you start losing mental capacity, then cannot already, you cannot thereafter then do an LPA. It's too late already. Then there's another application called deputyship. And like I said earlier, if you get lawyers to do this deputyship application for you, most of the time people do that. It's a very costly affair because it takes a long time. And when additional time has been incurred, that means you are paying more money to the lawyers. So I wouldn't advise it. Deputyship is a very painful process, but sometimes it has to happen, unfortunately, because especially during the older generations, they don't have this LPA, they don't have no concept of LPA. But now that this LPA is here, right, I really, really urge everybody to do it. All right, it's just in case kind of thing. But of course, somebody will ask me, but what if I don't lose my mind, then how? Then okay lah, then the LPA don't kick in lah. So it's like a safety kind of thing. It's just like why you buy insurance, right? You mean you confirm kena accident, man? No, but you still buy insurance, all right? You confirm kena cancer, man? You confirm need to lie in hospital, man? Not necessarily so, but you buy insurance as a backup plan. And LPA is just like that. It is a prudent thing to do. So really, it's about cost and time. Yep.
So let's say if someone wants to take up your call to action and, apply or obtain an LPA, how do they go about doing that?
Well, I tell you, why I said now this is the best time to do LPA. Okay, first, government very kindly announced they are going to waive the application fee. So they are going to waive it until 2025. Because if I'm not wrong, I stand to be corrected. The application fee is $75. But government waive plan. So that means you don't have to pay the $75 to file for this application with the Office of Public Guardian. Yeah, that's one. Second thing, recently over the few months, you go and Google the news, right? I think there is a recent Pro Bono SG collaboration with the CDCs, right? So I think they go to different constituencies and they have volunteer lawyers on standby to certify your LPA for free. Wow! That is amazing thing because right now in the market, okay, I'll share with you. I know, my peers are going to throw rocks at me, but I'll share with you the secret. The secret is that right now in the market, under the law, only 3 professionals can certify LPA. First, a lawyer. Second, accredited medical practitioner. And third will be a psychiatrist. Only these 3 types of professions can actually certify your LPA. In the market right now, if you get any one of these, right, to certify your LPA, the cost ranges anything from $25 all the way to a few $100s. So that's quite a big range. Okay? But imagine if you tap on this Pro Bono SG collaboration with the CDCs, right? And I think you need to go online and do the advanced booking, whatever it is, right? They have volunteer lawyers to certify for free. So, wow, free certification, then government waiver application fee. Wow, this is like the golden period to do your LPA. Like. So if I'm you, I'll do it like straight away, do the booking tomorrow, you know.
Okay, thanks, Joe. One question from our audience is, they have done the LPA, which is great, but the donee has passed away. So do they need to update the LPA? Is that such a concept?
Oh, okay. So because very good question, quite a technical one, but long and short of it is that okay, so under the LPA, right, it's not like will, because will you can appoint executor 1, executor 2, or even a third executor, fourth executor. I think for LPA, really standard form, LPA form 1, right? Essentially, you're just looking at appointing donee 1, donee 2, replacement donee, that's it. Okay, so for example, if let's say your donee passed away, then if there's another donee, the other donee will step up. But if let's say you only appointed one donee and the donee passed away, then I think what you do is that you go into the OPG website. That is where you have to go in, revoke your previous LPA, and then reappoint a new donee. Yeah, so you can just go into OPG's website and follow the instructions are there. So you can change your donee, you can revoke your LPA. Basically, everything is online right now. It's very, very easy to navigate.
Thanks, Joe. So maybe I would like to ask Dr. Liana, from a medical perspective, how do you determine whether someone has lost mental capacity, especially if their physical health is in rapid decline? How can you tell?
Thanks, Serene. Thanks for that question. Yeah, I also saw someone in the audience had a similar question about whether or not certain patients or certain groups of people have mental capacity. So it's a really important question when we're talking about all these future planning, to make sure that the person who's making these plans has the capacity to understand what plans he's making, right? So the first thing I wanted to share is the mental capacity assessment is something that every doctor is taught to do.
Okay.
So every doctor is aware of how to assess very basically the mental capacity. And what this involves is that the person who's being assessed is assessed on a particular topic. So there's a particular decision. There's no global sort of assessment. So they have to be able to understand what I'm trying to ask them. They have to be able to retain this information. They have to weigh it out. And then they have to come to a conclusion about it. Yeah. And so you can imagine when you look at different decisions, there are different decisions, there are different complexity. So if I'm asking a person, oh, how do you feel about going for this major surgery that involves the spine? There might be this injury, there might be this risk, there might be this benefit. That's very complex. Versus, what do you feel like having for lunch tomorrow? Which is a very simple decision. Yeah. So different people have different capacities also to make decisions at different points in the illness. Yeah.
An audience member has an interesting question is, what happens if the person's unconscious or is in a coma? Does that count as losing mental capacity?
I mean, certainly it does. It would, because one part of the assessment for this mental capacity is to be able to retain, to be able to repeat and show your understanding of the issue that's being discussed. So if you're unconscious, you are unable to respond, you are unable to engage or communicate, then that already means that you don't have the capacity to make any decisions. You don't have the capacity to express your preferences either.
So, I have a question about, and maybe this is for Joe, is that it seems like when you're mentally incapacitated, right, the donee can make a lot of decisions with regard to my personal being as well as my financial and dealing with my assets. Are there any safeguards against my donee, touch wood, abusing my trust and taking advantage of me?
Safeguard, like I said, the only safeguard is your common sense, okay? So for all the listeners out there, you got to really take note of this, very important, okay? Every year when I do this talk, I think this is the most important advice I will give to everyone. When you appoint your donee, please appoint somebody you trust, somebody you know. And most of the time, right, you will be, for this one, is a bit different from will. Most of the time, I think people will appoint family members as their donee. Because why? If you look at the two big powers you are going to give to this person, essentially you are giving the person the power to decide on your personal welfare. That means the medical doctor you're going to see, the treatment that you're going to have, the medicine you are going to take. You know, this is going to affect the quality of your life, you know. Second thing, property and affairs. You know, all your monies in the bank, your housing stuff and all that. That means you are giving this person the power to authorize, you're authorizing this person to transact, to do things on your behalf, you know, regarding your money. So, you know, we have seen some cases on the ground. And I kid you not, these are real life cases. You know, there was this uncle, right? Very funny. One day, he make an appointment to come and see me. So he said he want to do LPA lah. I said, okay. So of course, you know, I went into the room, I chatted a little bit just to test out his mental capacity. Of course, he's very lucid, you know. So then he brought this very young lady. Like this uncle is probably in his late 50s. The lady that he brought along is like 25 or 30 years old, very young. So I thought maybe it's the daughter lah, or maybe it's the granddaughter even. And then I asked, oh yeah, so who is this lady? Is this your daughter? Then the uncle tell me, no lah, in Hokkien say no lah, this one my lover. Then I shocked. I said, huh? Lover? I say, uncle, what do you mean lover? No, this one my lover lah. Girlfriend. I said, girlfriend. I said, girlfriend from where? Oh, no lah, because 2 weeks ago at the People's Park Center down there, the food court, I get to know her lah. Then we talk. She very friendly, so nice, you know. So she asked me, say, come here, do the LPA, put her as Dhoni. Then I got a bit worried. So I actually asked the lover, the young lady, to go out from the room. Then I speak to the uncle one-on-one. I said, uncle, you're going to give very big powers, you know. Are you sure you want to give it to your girlfriend or your lover? Because once you lose your mental capacity, the person can make a lot of decisions, you know. All right, what if the person sell away your house, kick you out, take away all the money in your bank? Then how? So that was when he realized. He said, it's so serious, is it? Then I said, maybe you want to reconsider, you know, getting somebody else as your Dhoni. All right, because I think that, okay, of course, a common question people ask me, but what if, let's say, I don't have anybody, I'm single, all right, I don't know who to appoint, no family members. I think that is where you can go online, you can search for professional Dhonis. There are professional companies that actually provide such services. Yeah, but don't just pick up any Tom, Dick, or Harry, or any Xiao Mei Mei, you know, at the food court on the streets, you know, to become your Dhoni. Please don't do that, okay? This is very serious. So please listen to this, okay?
Thanks. And it's also comforting to know that there's professional Dhonis out there, because there may be some who maybe they don't have relatives or friends, or maybe they might have outlived most of their relatives. Maybe this is for Dr. Liana. I think this is a general question around if, let's say, if you have onset or mild dementia, does that mean you are really mentally incapacitated and you cannot do an LPA anymore?
Yeah, I think that's a very common question because everybody's worried about your mental state. If you become a bit forgetful, can I still make a will? Can I still do what I need to do for myself and my family? So just because you have a mental illness, just because you have dementia, doesn't mean you don't have mental capacity. Yeah? Especially if it's early onset, especially if that memory loss may be very mild. It doesn't mean that once you have a certain illness, then immediately you have no capacity. So what would need to happen is that you would need to be assessed, or your loved one would need to be assessed. And again, it's based on what is the decision that we're trying to make. So if you are asking like, oh, can my mom who has early onset dementia still make a will or still make an LPA? The answer is possibly yes. So what are the steps to do is to approach a professional to go through the mental capacity assessment. My advice is for people who have a history of mental health issues or history of dementia, and we're not very sure. Sometimes he can remember, sometimes cannot remember, a little bit unsteady kind. I would say my advice would be to either go to a psychiatrist who can do a very, very detailed assessment on the mental capacity, or go to a professional who knows the patient very, very well in terms of their medical condition. So if they follow up with a geriatrician who is a certified LPA issuer, for example, you can talk to the geriatrician and get your advice from there. Yeah, it may be a bit difficult, for example, to ask a lawyer to assess for these particular cases
Yeah.
because they may not have that medical background lah, to make that decision. Yeah. And they may eventually also, correct me if I'm wrong, Joe, they may actually even also ask you to get an opinion from a medical professional.
That's
Yeah.
right. You are totally right.
So let's move on to our third topic, which I think is less well known, which is advanced care planning. So Leanna, are you able to share like what is advanced care planning?
Sure. I mean, this is something that we've been working on the medical side for at least a decade. And I think increasingly it's getting a little bit more traction, a little bit more awareness. So I think in short, advanced care planning is a conversation. So this is a conversation that you have with people that you trust and your medical care providers about what you want for yourself. Yeah. So that is really the summary of it. And this is really what happens in advanced care planning. So you start by just thinking, what is important to me? What's important to me now? If I'm not well, what becomes important to me then? You talk to your people you trust, so your family, your friends, your healthcare professionals, even others who may be your friends, a professional caregiver who you're very close to. Write it down, what you prefer. And you see in this bubble, I included not just advanced care plan, but also a lasting power of attorney. So this is like the trifecta of how you should plan your life in the coming years. Yeah. So think about what matters to you, what are your values, what are your preferences, and then write it down, make a note of it. And then once you have some decisions and you have some feelings about, okay, I think I need to share this, talk to a family friend and talk to a healthcare provider. And once you share it and we put it down, we can record it in your health records so that wherever you go, we'll try to make sure that these wishes, these preferences are known to everybody who provides medical care to you. And you can see all the arrows are double-headed arrows, so you can go back and forth. Doesn't mean that you think and then you write already, then cannot change. You can go backwards, you can go forwards. Even if you written it down, even if you shared it, you change your mind, you want to change a new ACP again, you can do that. Yeah.
How do you, because you mentioned it can be part of the medical record, so does it mean is there a particular doctor you must go to and say, hey, this is what I want, can you key it in? How does that work?
So I think what I mean by medical records is that it will be reflected on the national healthcare records. So whoever has access to that will have access to what you document your preferences to be. So similarly to LPA, we have training sessions for facilitators to do advanced care planning. And these facilitators need not be doctors. So we have health coaches, we have medical social workers, we have trained specific facilitators for advanced care planning as well, who are able to facilitate this conversation, who are able to help you to document it, and who are also able to help you to upload it into the system so that everybody knows what you wish for. Yeah. So I think what I wanted to share also is some concerns that people ask or some common questions that people ask about ACPs. So when I talk to some of my patients about it, some of the things they say is, don't worry lah, my daughter knows me very well. If the time comes, she will know what to do. Yeah. Or they'll say, why you want to talk about it now? It's very pantang, right? I'm still well, I'm not ill. Why you want to talk about being ill? Why you want to talk about dying? This is very, very pantang, very taboo. Yeah. Some other things that people worry about, like I said, once I put down my plans, I can't change it anymore. It's very, very hard to change it anymore, to find somebody to go through this whole process again. And the last question that I've heard on and off also is whether or not is it a legal thing? Do I need a lawyer to sign off on this document for me? So all these are the myths. And so the reality is that's not always true. So think of the last small decision you have to make for your loved one. So if suddenly you had to buy somebody you love their bubble tea order, some people know it off the top of their head. Some people are like, ayo, yesterday he said he likes it this way. Today maybe he will like it that way. So if you don't say, you won't know lah, right? The second thing we wanted to share is ACP is for everybody. Just like Joe mentioned earlier, of course, we don't wish for it to happen to anybody, but things can happen suddenly, like a road traffic accident, like a sudden illness. And so why wait for that to happen than try to scramble and figure out what to do, right? If you create a plan early, you share it with the people that you trust, then there is that reassurance that even if anything happens to me, I know that the people that I trust will look after me in the way that I want. Yeah. You can change your plans at any time. In fact, actually, we encourage you to review your plans regularly. So it's not uncommon if you've made this ACP document 4 or 5 years ago, somebody will come out and say, hey, do you want to look at it again? Shall we go through it again to just see if anything has changed about how you felt last time and now? Because life changes, and so your feelings may change also. And the last thing that you may be happy to hear is that it's not legal. You don't need a lawyer. It's absolutely not a legal document. There is no notarizing. There's no certification that's needed. Yeah.
Thanks. An audience member's asking, he has completed an AMD and he's asking what's the difference between an ACP and an AMD?
Yeah, I think that's a really good question. Yeah, and I think it's often very confusing. There's so many letters, right? ACP lah, AMD lah, LPA lah. So, we try to figure out what is useful at what point in time and what you should give your energy towards. So AMD, for everyone's benefit, is called Advanced Medical Directive. It is a document that you can fill out with any doctor. And it's a very specific document that says that in the event that you are very, very critically ill and you require extraordinary life-sustaining measures to tide you through this critical illness, that means you're at death's door already, that you do not want it for yourself. So that means let me die a natural death in this particular circumstance. So you can tell it's a very, very, very specific situation that the AMD comes into play. That's the first part about it. The second part about an AMD, which I find very challenging as a medical professional, is how do we get hold of this AMD? So for ACP, I mentioned it's on your national healthcare record. So as somebody who's providing care to you, if I access your records, I can see your ACP documents if you've made it. For an AMD, I by law am not able to ask you or your family members, does this patient have an AMD? I cannot ask.
Oh, you cannot ask?
No, I cannot ask.
Okay.
Yeah. So because the worry is that knowing a patient has an AMD, we don't want that to cloud the medical judgment. Yeah. So in the event that the patient is very, very critically ill, we have to call a number that will link to another number to try to find out from the registry if this patient has an AMD, and then they will kind of U-turn and come back to us to say, yes, this patient has an AMD, or no, this patient doesn't have an AMD. The difficult part about this is that this number is an office number, so it's subject to office hours, which emergencies are not subject to, unfortunately. So if I have an emergency at 3 a.m, I'm not able to get a hold of any of this information at all. Sometimes the turnaround time is long. So even if I call, I may not get the answer immediately. It may take some time, some hours, even some days to get the answer back. And remember, this is a person who's on death's door already. So I need to make the decision immediately. A lot of times, I don't find the AMD particularly useful. Yeah. And a lot of times in that moment, when the patient is so critically ill and at death's door, we act in the best interest of the patient, or we refer to an ACP, which is very readily available. It takes me 2 minutes to find it. Yeah.
So even though you can't ask the family member whether there's an AMD, but the family member can tell you, hey, there's an AMD and this is what it is? I mean, is that allowed?
Even if they tell you, we still have to go through the process of verification.
Ah, I see.
We cannot just take it at face value, because family members also may have other reasons to not want to continue life-sustaining measures, and we cannot just accept their word as what it is. Yeah.
So besides the AMD and ACP, there are several types of life planning in Singapore. Can you just very quickly just share with us what are the other different types?
Sure. So I think quite commonly we look at ACP as one of the life planning, AMD as one of the life planning, and LPA as one of life planning and wills. I think it's quite confusing sometimes to say, oh, when does it kick in? What is the difference between all the three? So I just made this little slide to help to outline it lah.
Mm.
So ACP is what we were talking about. It's not legal. It is just a discussion about your future care preferences and how you want to manage your illness as your illness progresses. And this helps you to tell the people that you trust and your medical team how to look after you. An LPA, like Joe mentioned earlier, is in the event that you lose mental capacity. It allows your donee to make decisions on your behalf. And this is a legal document. AMD is also a legal document. And again, like I mentioned, in the event that you require extraordinary life-sustaining treatment, it accounts for your preference. And the last is the will, which is also a legal document, is in the event of your death. So I think to make it even clearer, along the trajectory of life lah. Yeah. So I think if you move to the next slide. In different parts of life, you will have different things that kick in, right? So at the start of life, when you're still very, very healthy, not a lot of things kick in. When you first start to get your illness, also there's not a lot of things that kick in. Your LPA starts to kick in when you lose mental capacity. And that may be at the beginning of your illness, the middle, or towards the end of your illness. AMD kicks in when you're really, really, really terminally ill. And the will kicks in only after you pass away, right? ACP is different than all these because it's the only sort of life planning that has relevance throughout any stage of your life. So you can do an ACP when you're absolutely well and you have no illness. You can do an ACP when you first start to get some illness. You can do some ACP when you have more serious illnesses or as your illnesses progress as well. So it's not a once-off discussion. You may start a discussion, revisit, change things along the way as well. Yeah.
Thanks. I think an interesting question from a commentator, an audience member, is that can the ACP be in different languages? What happens if their relative can't speak English?
That's a very good question. And we do face this with a lot of our patients as well. We have patients in nursing homes who only speak dialect. We have patients who only speak a particular language and only understand a particular language. That's why it's important that our facilitators come in many shapes and forms, walks of life. We have facilitated ACP discussions in many, many languages. The documentation eventually will be in English, but the discussion can be in any language that you prefer. I've facilitated discussions in Malay and in English. My colleagues facilitate discussions in all sorts of dialects, in Tamil, yeah. And so this is something that's easily overcome. Yeah.
Thanks. I think good to know. I think due to the constraint of time, I think next I'll invite Patrick to share about what are some useful tips and resources.
Yeah, thanks, Serene, and really thanks to Joe and Dr. Liana for sharing. I've been patiently listening in for the last 50 minutes and wanting to give everyone some take, and also in a way augment some of the things that Joe has shared as well as Liana has shared, and also give you all some practical handles and pointers. Because of my engagements with many workers and residents, I do hear some of these questions being thrown. So before we go to Q&A later on, I thought useful to share. I think the organizers of LawWorks have through the chat gave you all the links to all the different things or different resources that Joe and Liana have alluded to. And I think it's very useful. Yeah, so make full use of it and copy those links down and save them as your favorites. But otherwise, I thought I just go through a laundry list of things I wanted to augment to what Joe and Liana mentioned earlier. And these are things that come up quite often. Firstly, I think in the area of wills, I thought good to let everyone know, everything can be willed, but take note of CPF nominations. Take note of CPF nominations because that's one of those few excluded categories, meaning a will cannot, you cannot override, in a way, your CPF nominations in that sense of the word. So likewise, CPF nominations, please make your CPF nominations, especially when you have changed your circumstances. Maybe a divorce, someone passes away, or some of the beneficiaries that you have nominated. Well, in fact, any change in the circumstances, you should review it And now it's been very easy because now you can go to any of your service SG centers across Singapore to do your nominations there. So there will be an online service, and then the SG service staff will act as your witness. So actually, you can do it quite easily. You don't need to really, summon down people and friends and stuff like that to be your witnesses. And so the CPF nomination is quite easily done. So please do it, and do it carefully. That's one. Second, when it comes to, for example, our HDB flats, many of us live in HDB flats. You are usually, for example, you apply for your co-owner or you're joint tenants with your wife or your children or your spouse or your grandparents, etc. So there may be it's a joint tenant relationship. So there's something in property law called right of survivorship. So take note. Yeah, I've been through this because many 3 decades ago when my dad passed on, and I was kind of like helping in the post funeral arrangements. That you need to go to HDB and execute and inform of the death, and then the remainder, or should I say the entire HDB flat will go to the other person, the other co-owner or joint tenant. That's by operation of law. But there's some basic fees and charges you need to pay. And I thought good to let you know that you can do this quite easily, and you can add new persons. I remember many years ago, a couple of decades ago, when my dad passed on, passed over the property because of right of survivorship to my mom, and then she included my name in it and stuff like that. So take note, that can be done quite easily at the HDB branch or headquarters. Third is joint accounts. This has come up quite a bit in my engagement with residents because it is usually a case where there's the loss of mental capacity. Yeah, loss of mental capacity. So there are few things. Good to have joint accounts because especially in joint accounts where there's both either husband or wife. I'm just giving a husband and wife scenario. You can actually, if one passes on, again, the other person can have the powers to withdraw monies and put monies and deal with that remainder account. I think that's the advantage of that. Of course, some of us don't want to have joint accounts with someone. We want to have it, privately. But take note of this. If it's joint account, then both have equal rights to that monies in case someone passes away. So that's another one I thought good to take note of. And I know of situation. That's why Joe mentioned earlier about the importance of the LPA, because the deputyship process is much longer, costs more. I have one resident who came to see me not too long ago, who he was looking after the mom. The mom, he's single. He's looking after the mom, the aged mom. The mom is kind of like demented and with multiple mental challenges, and therefore sort of lost mental capacity. And here he is, he's jobless and wanting to send her for medical appointments, operation and stuff like that. And he doesn't have monies. So lo and behold, she has a bank account. The bank account has quite significant amount of money, but he cannot even touch the monies until such time he goes through the deputyship process, unfortunately. Because if he had an LPA, and then he would have, if he had been the donee, he would have made things much more easier. So that's where where Joe shared earlier the challenges. This is a great example of on the ground. We are seeing many of these cases where they forget about doing an LPA, and then these are the consequences you have to bear: legal costs and also time wastage. Because sometimes you don't have the luxury of time, especially if the elderly person who has lost mental capacity would have a critical illness or needs to go for a major op or some cancer treatment, etc. So, and which are costly. So take note of that. I thought that's important. And another point also on who is the executor, I thought very, very important. I learned something from Joe as well. Besides, he shared about the choice of donee. I think the choice of executor for a will is very important. Very, very important. Well, naturally you think, I put my wife as executor. And if anything, she deals with it. And what happens if you go on a family holiday and touch wood, the entire family goes? So who deals with it? Or you go on a couple, a romantic holiday, and then your kids are just saddled with that, and there's no executor because technically your mom was the executor, but both mom and dad gone. So I think, this sounds a bit morbid, but really these are issues you need to think through. So it's good to, if you really can't help, get a professional executor. If you can, try your best to get someone who maybe close family friend, someone who is basically outside the family, so that things can be handled post death. Sorry, a few other points I thought good to highlight to everyone. Another thing is about advanced care planning. I attended many funeral wakes, residents, and acquaintances and friends. I thought one thing I noticed and I hear often is family disputes. Why? Because there's no proper instruction given to whoever that's left behind, the family members. Especially critical when you have many family members, you have relatives, you have god brothers, god sisters, you have siblings. It's going to get complicated, and a lot of some of you was watching this may agree with me. Some of the family disputes or quarrels end up during funerals because of disputes over, for example, the deceased is actually a Christian. Why are you doing it in Taoist kind of funeral? Or why do you use this picture in front of the coffin? Why not something else? Or simple instruction like we don't want all this fanfare, we just want it simple. Or we should have this, we should not have that. So I thought all these issues are practical issues. I learned from one of the sessions which Joe and I did at my constituency, where the undertaker shared about all this, where all these are the challenges where they witness while trying to administer and helping with the checklist of items to prepare for funeral. You get a lot of quarrels and a lot of disputes and disagreements. So I thought good as part of advanced care planning. I think Dr. Liana alluded to it, giving instructions. Some of these things that mean a lot to the person as well as to the family. I thought good to clarify it. Again, morbid, but needful and imperative. And finally, Dr. Liana did not may not have shared, but not just at Woodlands Health, but across Singapore, we have our different clusters. I think the advanced care planning service is available across all clusters. So don't all go to Dr. Liana, otherwise she'll be swamped. Yeah, but I thought these are a few pointers which I hope to augment and remind everyone.
Okay, thank you, Patrick. So I think we'll next move to the Q&A session, and I think there's quite a lot of questions that I'm quite keen to go through. So a gentle reminder to our audience, it's not too late. If you have any questions, feel free to submit it through Pigeonhole. You can also vote up questions that you really would like us to answer. So I think one good question that was being asked by an audience member is, what happens if this is regarding wills, okay? And maybe this is for Joe. What happens if the deceased has actually debts, right? So does the beneficiary need to pay off the debts? How does that work?
No. Okay. Wait. Okay. So okay, that's the reason why just now earlier we talked about the fact that even though the law doesn't require a lawyer to draft a will, anybody can draft a will, but we would advise people to get a trained professional to do it, right? It's really because of this reason, because the wording, the way we phrase it is important. Okay, so for example, an issue like debts, right? Some people, they say that, hey, actually there's a loophole, I know I got stage 4 terminal cancer, so I'm going to borrow a huge bank loan, like $1 million from Citibank. And then a few months later, I passed away, then no need to pay, no need to return to the bank. That's not true, because under the law and the way we craft it, right, there is actually a paragraph where we state that, all the assets under your name, okay, after you apply for the grant of probate, so-called you apply for the court order, right? So once the court has given the order, you have to actually pay off all your debts first. And the balance of it, then that can be distributed to your intended beneficiaries. All right. But of course, that said, right, your debt doesn't pass on to your beneficiary. You know what I mean? It doesn't pass on. It's like there's a Chinese saying that say, 父债子还, which means that the father owns the debt, the son pays for it. This is not true. So
that's good to know.
You worry in case your father, mother, before that, own a mountain of debt. It doesn't work that way, that when they pass on means you have to carry on the debt. It doesn't work that way. They will just use the estate of the deceased to offset. If let's say at the end, after paying off the debts, then your asset becomes negative, right? Then you have nothing for the beneficiary, right? That means the estate is insolvent. That means there's nothing to distribute already, lor. This is what it means, lah. So actually, we have seen cases whereby a lot of people, they say, oh, I have this asset, I have that asset. I want to give like $100,000 to this favorite son of mine. But we always tell them, we say that maybe right now you have the 100,000, but along the way, right, we always say that it's actually good practice, like Dr. Liana mentioned earlier, whether is it for ACP or for, for LPA or for whatever life decisions, it's always good to have a periodic review. Same thing for will as well. When you draft a will, you execute a will, try to do it like once every 2 years, once every a few years. When you reach a certain milestone in your life, it's always good to review it and amend it accordingly, because you may have $100,000 today, but 2 years later, you might not have that $100,000 again. You see what I mean? Then maybe that's something that you want to amend, because you cannot give something that you don't have, or something that doesn't belong to you. That's really the long and short of it.
Thanks, Joe. Just grouping some questions together. I think it's on the topic of, I think, beneficiaries. Of course, you can express in the will how you want your asset to be dealt with. But what happens if the beneficiaries come together and tell the executor, like, look, can you give it to someone else? Or can you sell an asset away? Like, must the executor listen to the beneficiary? Can the beneficiary do that?
No, this one we have seen before, so, and in real life cases as well. Renounce it, law. I mean, we have seen family squabbles over this, like for example, the mother has like 5 children, decided to give all her assets, right, to all 5 children in equal proportion. But I think there's one child, right, decided, I don't want to be a part of this. I don't need the gift. So what happens is that that kid actually renounced it and said that I don't want it, so you can distribute it among the 4 others, . So there's actually proper legal legit way of doing this, . So if you don't want it, you can always renounce your right, or maybe you can even just take it and just donate, to a charity organization or whatever, right? So I think really the point is this: when the person doing the will, whoever that is, let's say you are still alive when you're doing this will, don't do it in silo, don't do it in secret. Have a conversation. Whoever you want to appoint as an executor, or whoever you intended as your beneficiaries, have a talk, have a chat about this. Like what Patrick mentioned, I know certain issues regarding these few topics a bit morbid, a bit taboo, a bit pantan. But I think now in our modern age of time, you really need to have an open conversation about this, so that there are no misunderstandings and no miscommunication, when the eventual does happen. Yeah, so it's good, because we have seen, especially the seniors, they say, oh, you know what, I'm going to appoint my executor, my son, and I'm going to give it to another son of mine and all that, but I don't want to let them know. I say, why? I say, because I scared later I let them know, then they don't want to work, they wait for me to die. I say, I mean, that is quite a logical fear, but I'm saying that, but the downside to that is that if you don't let them know, right, they wouldn't know where to locate your will when you passed away, right? They don't know what to do. They don't know, what you have done or not done, you see. So I really think it's good to have a conversation with whoever you want to appoint as your executor or your donee for LPA, or even the beneficiaries, what are they getting from you, I think it's always good to have that open conversation. Yeah.
Thanks, Joe. So, an audience member's asking, if I don't want to receive life-sustaining measures, do I state it under the ACP or the AMD? Maybe Liana?
Hi, thanks for the question. Yeah, so if you don't want to have life-sustaining measures, both the ACP and the AMD can help to indicate that for you. But for me, the easier access document is the ACP. So I would encourage you to document it in your ACP. So when you go through the ACP document, there are different kinds. One of the topics and one of the big discussion topics will be life-sustaining treatment, such as CPR and things like that. So that will be very clearly indicated as part of the ACP discussion. Yeah.
Thank you for that. Perhaps a popular question, quite voted up quite a bit for Joe, is that, well, I don't mind if my property is distributed in accordance with the Intestate Succession Act, right? So maybe I really think I'm going to pass it to my wife and to my children, Why not just let it kick in? Why bother with a will?
Okay lah, whatever rocks your boat lah. I mean, if that is your wish, then so be. I mean, but the thing is that, okay, I mean, if you ask this question, that means you must know a bit about the Intestate Succession Act, right? I mean, whoever is the poster of this question. But if you look at, for those who are not aware, the Intestate Succession Act, right? This legislation by government, basically it states down, assuming you die without a will. All right. So it states down clearly the different tier of blood-related kinship, how they are going to distribute it for you. Because nobody knows your intention, right? So the thing is that end up they have to distribute it accordingly. So for example, real life example, husband and wife, no children. So if you passed away already without a will, then of course, how the distribution goes is that, okay, it goes to your spouse, right? Okay, assuming you have a spouse, you have 2 kids, then 50% goes to your spouse, another 25 go to your respective kid, you see? But assuming if let's say you're single, okay, then according to the act, of course, then they will go back to see whether, you should go back ideally to your parents. But assuming if your parents are already, they predeceased you, they passed away before you, then they will find the next of kin, maybe your siblings. If you don't have siblings, or maybe your auntie, uncle, your nephew, your niece, so on and so forth. So I mean, of course, to answer this question, if at the end of the day you don't mind, it doesn't matter. As long as they give it within your blood circle, then sure, by all means lah. But I think commonsensically, and this is also quite commonly seen on the ground, is that after you work so hard all your life, whether you have a family or not, I think ultimately you want all these assets to go to your intended beneficiaries, or according to your wishes. Because we have seen people, I mean, they are single, they have some assets, they don't know who to give it to. But I think this is also very heartening to know more and more Singaporeans we have seen, they are giving to charitable causes. They are giving to charitable organizations, whether it's animal welfare groups or religious organizations, or even to a disaster relief kind of aid group or funds, right? It's very heartening to see more and more Singaporeans are doing that, too. And I think you should do that. Because ultimately, the law states that if you really die without a kin, they can't locate your kin, you are really all alone in this world, right? Ultimately, the last stop is that all your assets will be declared bona vacantia. What it means is that it goes to the government. It goes to the country. That's what it means, really. So, of course, if you can, then just give it according to who you want, your intended beneficiaries, or to donate to a good cause. But if not, let the state distribute it for you.
Yeah. Well, Joe, maybe another advice for this few that asked this question would be like what you alluded to earlier, that in terms of the cost of a letters administration vis-a-vis a probate, as well as the time taken, would be much longer in the intestate succession scenario. Yeah.
Right. Yeah, I mean, exactly. Wonderful point by Patrick. Really, I think let's not forget about the cost involved and the time involved as well. If you say that, you don't want to draft a will, you let it be distributed according to the Intestate Succession Act. But like I said, the cost and the time involved will be long, will be a lot more. So bear that in mind.
Yeah, I've seen personally complications in intestate succession cases where the public trustee comes in, and then you have a situation where your siblings, or it's complicated when your families are very big, and then there are many beneficiaries, so to speak, even under the Intestate Succession Act, many siblings, and siblings can be in different parts of the world, and the siblings are very old, for example. So it's complicated. I've seen some where there are 2 of the siblings are in China, different parts of China, and then so it adds to all these complications. So that's why we encourage for more expeditious resolution.
Liana, must the donor of a LPA, must it be a Singapore citizen or PR?
Sorry.
So
for
the LPA, right, you have a
Yes.
donee. So must you be a Singapore citizen or PR?
Maybe I should ask Joe.
Or maybe
Yeah,
Joe.
Joe. Yeah, I'm not aware of the laws around
What's the question?
the donee selection.
Okay.
Yeah.
So for LPA, you have a donee. Must the donee be a Singapore citizen or PR?
This one,
Yeah.
Yes, of course. I mean, ideally, I mean, what commonly, wait, this, the donee, or this for LPA, is it?
LPA.
Yes, of course. Answer is yes. Because the thing is, anyway, for LPA application, just to let anybody know, the actual application process right now, everything is digital. Okay, no more physical forms and all that. So you go to OPGO, which is the OPG's online website, and then that is where they have usually, like me, because LPA, just now I think we forgot to mention during the talk, is that essentially there are two categories of LPA, LPA Form 1 and LPA Form 2. So the long and short of it between these two is that Form 1 is standard form, which most of us, more than 95% of Singaporeans, they will use Form 1, or even more than 95%. Form 2 essentially is customized. All right. So coming back to Form 1, right? You do it online. And the thing is that now everything is just like what Patrick just now mentioned about the efficacy of doing your CPF online nomination. Now LPA, right, is also just like CPF online nomination, is very efficient. So basically, you just, whether you as a donor or donee, right, you use your respective SingPass to sign in. All right. So to really to answer this question, yes, the answer is yes. You know, you need to use your SingPass to actually log in, whether to do it as a donor or to do it as a donee for your LPA digital application. Yes.
So I think there's this, I think this question is from a caregiver, right? And who has to take care of, I think, well, they didn't mention whether it's a child, but let's say it could be a child, right? Who needs lifelong caregiving, right? And they really want to try and provide for that child. So can they, in their will, somehow ensure that it's not so simple as, okay, because the child will always need caregiving, all right, in this particular situation. So is there a way to put in the will, like, look, someone would take care of the child, or there's a certain monthly expense to hire a maid to take care of the child? I'm not sure whether you encountered situations like that
For wills, is it?
for wills. Like, how do you deal with a parent who has a child who needs lifelong caregiving?
Well, I'm glad actually you asked that question. Okay, so I will answer this question in two parts. The first part, if we talk about a normal child, that means a child who is not like special needs or anything. Usually we will advise the person who wants to do the will, if they have a young child, that means, or somebody below the age of 21, we will advise them to actually put in a guardian clause, who you want to appoint as a guardian, apart from your spouse. Because I think, without going to technicalities, under the law, your spouse is actually the biological guardian. So if anything happens to you, you pass away, right, the other surviving spouse will be the biological guardian, all right, in the eyes of the law. But there's another thing called testamentary guardian. That means the guardian in the will that you appoint. So usually you can also appoint a testamentary guardian. Okay. So, I mean, we will advise them to do that. And also another thing called testamentary trust. Again, without going into technical specifics, is that basically you can lay down your specific wishes as to how you want the gift given to this child, right, to be distributed based on age. So we have done cases whereby, like, for example, they say, oh, from below the age of 21 years old, every month you should give the child, let's say, $2,000 for maintenance and all that. After that, from the age of 21 to 25, when they are still at university, I want to give how much. And then after that, for the entire balance of the gift to fully give out to them at the age of 30 years old. This is just an example. So this is the form of a testamentary trust. We have seen it, we have done it. So it can be that specific. But of course, when you go to a lawyer or a will writing company to get them to do something like that, of course, there'll be additional costs. You incur higher costs because these are very specific, very technical clauses. Yeah.
Joe, sorry. So, and that segues, I mean, we'll touch back shortly on the child special needs, which I think is what the audience members probably trying to get at.
Yes.
So, I mean, so if you have a beneficiary who's below 21 years old, that means they will not receive the gift.
No, usually they will, because under the law, right, upon the age of 21 years old, they will be an adult. All right. But I'm just saying that, for example, they have very specific instructions as to how they want the gift to be given out, at what stage of the child's life. They can actually indicate it in their will, you see. Yeah. So to answer the second part of the question, which I think is probably what the audience or the person is trying to allude to, special needs.
Yes.
This one really, I think it is very kind. It is very smart for the government to set this up. This is actually set up by the government. It's called the SNTC. Okay, Special Needs Trust Company. Go ahead and read it up. Okay, so this is a professional body. Okay, so if you have a special needs a case, a special needs child, of course, all the parents will be worried, what happens to my child after I passed away, right? I think this is where we will advise them, go to SNTC, all right? And so in a way, that means long and short of it, you actually put SNTC as the benefactor of your will, of your wishes. So that means all your assets will be given to them, and then they will carry out your instructions of providing for your special needs kid. That's really the long and short of it. So for more information, please go to their website and get in contact with them and speak to them. They will advise you on the next step to take.
Thank you. I think this is very, very helpful. Next question is, what happens if the beneficiary in your will passes away? So what happens to that gift?
So for example, if you got 2 child, right? Then you give 50%, 50% equal shares, right? Then what if one kid, right, passed away? Then that means technically, you have a partial intestacy situation. Okay. So that means the child who is still alive, the beneficiary, right, will get a 50%. But the other 50% will be a question mark, passed away already, So for a situation like this, we will advise customers to put in a pre-deceased clause. So what it means is this. So I got 2 child, 50%, 50% equal shares. I'll put in a clause number 3, a pre-deceased clause, to say that if anything happens to any one of the child, the one who is deceased, right, the portion will go to the surviving child. So it's a loop. So it covers all areas, whether is it child A or child B, right, that passes on, right? Doesn't matter. It goes within the family. The assets is still distributed within the bloodline. I mean, if that is the intended wishes, but because there can also be a pre-deceased situation whereby the gift is given out to another person. For example, I give to my 2 child, assuming that any one of them passed away before me, then the gift given to them will be given to a charity organization outside of the blood, also can. But basically, this concept is called pre-deceased clause.
Okay, so let's say worst case scenario, there's no pre-deceased clause. So what happens? Let's say you're giving it to your 2 children, and let's say your son passes away. So for that half, does it go to the son's estate and then distributed according to the son's will, or what happens to that?
No, so like what I mentioned earlier, if let's say you don't have a pre-deceased, that means that the person, the beneficiary, right, passed away before you, and then so that portion is what we call intestate, So of course, by right, according that portion will be actually distributed according to the Intestate Succession Act. Right?
Okay.
Yeah. But of course, if let's say, for example, you give to the child is an adult, assuming, and the child, he or herself, actually has a will on their own, right? Then of course, it will go to their estate to be distributed according to their respective wills, if that makes any sense. Yeah, it's a bit technical. Yeah.
So I think for Patrick, a more philosophical question from the audience is that not married, no children, based, I guess, on your experience on the ground, have you observed, like, what are some possible beneficiaries that you observed maybe singles can will or deal their assets to?
Yeah, I think most of the time I see 3 scenarios. Firstly, to charities, I think often they do set aside to designated charities. I think that's happened in many cases. Second, also to religious institutions. That's quite another common area. I think, and third one is associations or even groups or various NGOs or not-for-profits which the deceased may have had very close relations with, like what Josephus shared earlier on some. It could be an animal association. It could be any particular association which he or she, the deceased, may have been, when they were alive, very involved in and felt for the cause. So I think these are some of the scenarios we have. Charities, or could even be very close. I've seen cases where they actually, I mean, it's not a lot of money, but they actually bequeath it to the in the will to their neighbors and very close friends, and who help kind of look after them and during the dying years, in that sense. So I think these are the various scenarios which I've seen on the ground.
So maybe last question for Joe. Are you able to put conditions in your will? So for example, if my son takes care of me till I die, then he'll get the house. But he doesn't do that, he won't get the house.
Okay. Wow, how to answer this question? Basically, of course, like what I mentioned earlier, you can do a lot of things in your will, but the question is whether your executor can carry that out or not is another thing, right? But to answer this question specifically, actually you can do something like that, but this is not a will already. We will say that you should set up a trust. So if you set up a trust deed, this is another form of it. Then that is where you can be very specific. But usually, we will say that trust deed, right, is usually for people with a lot of money, you know, like what we see in the movies and all that. Like this is a tycoon, you know, he says that, oh yeah, you know, I got 5 children, you know, I will give them money when they graduate from this university. So they marry this girl, must give birth to like 2 grandsons and 2 granddaughters. Then they will get this portion. But what you see in the movie, this part is true. Then when the old patriarch passed away, then suddenly you see the lawyer carry the briefcase, appear at the bungalow and say, I'm your father's lawyer, so please gather. I'll read out your father's last will. This is, in real life, we call this a trust deed instrument, a trust instrument. So yes, the answer is you can do something like that. But like I said, it costs you a bomb. It's expensive. Usually they charge a percentage according to the estate that you have, you know, for them to carry out all these wishes even after you passed away. But if not, I tell you, keep it simple and review it every 2-3 years. Then you see whether your children got listen to you or not, want to give more, want to give less, which one treat you nicer, then you give more. That should be the more practical way of doing things, if you ask me.
Thanks, Joe. So I think before we close, I'd like to ask for each of the speakers to maybe give one quick key takeaway. Maybe Liana, if you have one key takeaway you'd like to share.
Sure. Yeah, so I think these are all pieces of a puzzle. My big takeaway is if you want to do one, take a look at all of them. So these tools don't exist in isolation. They work best when they work together. And the person that you choose to help you with these decisions is the most important decision that you make.
Joe?
Okay, really, this is to lead off from Dr. Liana. Really, if you want to do one, you do all. And correct now. So I will sum it up by saying that there are 5 things you need to do: a will, lasting power of attorney, ACP, CPF nomination, and then of course your critical illness and your life insurance plan, which most Singaporeans would have. Once you have all 5, you are ready to take over the world. Do whatever you want, okay? So brave new world. But please do this 5 first, okay?
Yeah,
yeah, Patrick.
Yeah, as for me, I like all these primers, Joe will know. I would ask you all to remember law. Law. What does law stands for? Lasting power of attorney, advanced care planning, and your will.
Wow, okay. A fancy acronym from Patrick. So thank you again to all our speakers for joining us today. And to our participants, we hope that you found our discussions useful. If you are facing any issues and if you are a NTUC member and keen to register for a legal clinic session, you can write to lawworks@ntuc.org.sg. If you are a non-NTUC member, maybe this is a sign, do consider to register as an NTUC member, or you can approach Pro Bono SG at help@probono.sg. At the end of this webinar, a survey form will pop up on your screen for your completion. We appreciate your comments and feedback as we'll use them to improve future webinars. And with that, on behalf of Pro Bono SG and NTUC, we would like to thank all of you for joining us today. Have a good week ahead. Bye.
Bye.
Thanks, everybody. Take care.
Good night.